Hello and welcome. Today we're going to be talking about how you can build trust with your attorney. So here's an interesting thing. Most people don't think about this because, well, why would they? But you probably actually know your attorney better than they know you because you've done the research. You've looked at their website. You've gone on their social media. You've looked at fill in the blank. You've looked at their reviews, if they have them. There are lots of things that you can do to get to know your attorney before you hire them. So you can check the bar website to make sure they're listed. There's all sorts of things, and that they don't have any, that they don't have any complaints against them or any type of disputes with them. So there's lots of ways that you can know your attorney before they know you. But there's not as many ways for attorneys to know their clients before that, right? Like, I can't research my clients until I know you're interested in my services. So today we're going to be talking about how you can build trust with your attorney. As always, this is not a complete exhaustive list of things that you do or don't do to help you build that trust. So if you have ideas of how you can build trust with your attorney or how your attorney can build trust with you, that's another part of this, because you might know them better, but it takes two, right? It really does. So make sure you put in the chat, what are things that you can do to build trust with others so that we can learn from each other. That's the beauty of the internet, we can learn. So let's get started, shall we? So the things that we're going to go over today are, first of all, Google research versus legal experience. Why most, but not all, initial consultations aren't free. We're going to dispel some myths about cases. Not every case is worth millions or even close. Okay. The importance of being honest with your attorney. Cannot understate the importance of this, and we will go through those steps today. So keep these thoughts in mind. I'm going over the highlights so that you can get a feel for what we're going to be doing. We're going to talk about confidentiality, what that means, attorney-client relationship within the context of you hiring an attorney. And we're going to also talk about realistic versus idealistic outcomes. If you have questions, please leave them in the chat. The other day, I apologize if this person comes on the channel again. I didn't see their comment, and I really wanted to answer it, and I've been trying to find them, but I can't. So I hope if you left a comment the other day about your settlement, that you will hop back on here and give it again so that I can answer it on air this time. So with that, let's go ahead and get started. One of the things that you have to know, is that Google is good as a Q&A type situation. And so what do I mean by that? Google only knows the answer to the question that you ask it. It doesn't know the next 5 questions. It doesn't know the next 10 questions. It can't answer strategy. Should you do something or should you not do something? Okay. So a lot of times when you go on Google and Google, can I do this, or, this problem or whatever, you're going to get a lot of information, like a lot. And as is true with a lot of information, some of it might be true. Some of it might not be true. Some of it might be skewed by jurisdiction. It might also be skewed by the person that's posting it, because not every jurisdiction is the same. Not every attorney is the same. Not every experience is the same. So you're going to get a lot of information that might work, but won't definitely work. Okay. So don't use Google properly. And we'll talk about how you can use Google properly when you're working with your attorney or when you're looking for an attorney rather than just straight up trying to Google and solve all of your problems. The next part of that is that the best use of your time? It's one thing to understand what you're going through, But what if strategically it doesn't make sense to do the thing you're about going to do, and you have no idea why that would be true? And if you don't consult an attorney to discuss that with them, you might do something that could permanently damage your case or make it a lot harder to win. So that's why it's like, you know, you don't hire a plumber to necessarily fix your pipes, right? You hire a plumber to know where to hit to fix the pipes, okay? It's a very important distinction. And that's the same thing with an attorney. Like, you can go to law school yourself. You could represent yourself pro se. But is that the highest, best use of your time? You could research the heck out of things. You could draft your own motions. You can do all of this other stuff. But is that the best use of your time? Okay. And case in point, say you make $30, $40 an hour, $50 an hour. We'll say 50, right? If it takes you 10 hours to do something, then your minimum output is, or your minimum loss is $500. If I can solve that same problem in an hour, then it makes a ton of sense for you to hire us to do that work for you. Now, that isn't true in every situation, and I'm not saying that you should follow this to a T on everything. But for the most part, hiring an attorney is going to be a lot more efficient, and you're probably 9 times out of 10 going to get a better result with an attorney than trying to do it yourself. And I know some of you are sitting, well, of course he's saying that. He's an attorney. But you're not hiring me to do anything. I'm not telling you this as my potential client. I'm not telling you this as a client. I'm telling you this as an attorney to a human being that might need legal services at some point, right? I don't get any pecuniary gain out of this. I'm doing this for your benefit. So it makes a ton of sense to hire an attorney. The next reason, and probably the best reason, is while online research can give you a general understanding of something, your attorney's advice is based on specific laws, precedent, and experience. And that's what you're paying for, is experience. You want the beautiful, it's funny, beautiful. That's how my kids talk, sorry. The beautiful experience, that's what you're paying for, is experience. You're paying them so that you can navigate your legal matter successfully for the least amount of difficulty for you. Okay, that's the point. And when you value that experience, you're going to have a significantly more successful outcome than if you try to do it yourself. Again, what would you rather be doing? Legal research, legal writing, or off with your family, off at the beach, doing literally anything else than doing the legal work, right? That we enjoy doing. Most of us, not all, but most, enjoy doing that legal work. So where would you rather put you can always earn more money, okay? That's true. I'm not saying money grows on trees, grows on plants in the US, but it isn't that simple, right? Money, I understand, but the one thing you can't get back in life is time. There's no amount of money that can buy a moment of time. It doesn't exist. So focus your activities, your legal thinking, right, when you're having a legal problem, on what's more valuable to me, my time or my money. And I can't answer that question for you, but I can tell you your time should always be more valuable, should be, than your money. You can always earn more money. You can't earn more time. So make sure you're spending your money to acquire more freedom and less stress, headache, and all that other stuff. Okay, so if you are going to use Google before you hit an attorney to hire them, use it as a resource to familiarize yourself with legal terms or basic concepts, but defer to your attorney's judgment for your specific situation. Give them the opportunity to do the job that you're hiring them to do. You're 9 times out of 10, like I said, going to have a significantly more successful outcome with an attorney than without. And what is your time worth? And I would say infinitely more than the cost of a new attorney or of an attorney. So as you're thinking on these types of things, make sure that your decision making is based on not just on what it costs you. are funny, and I'm not, everybody's different. I'm not trying to judge here. But a lot of people will be penny wise and pound foolish, right? They'll pinch their pennies to the demise of spending their money on the things that are really important. And if you've got a legal matter that you're struggling with, it's not like that's an insignificant event in your life. It's probably a pretty significant event. And that's where your money should be spent, right? Is on that, so you can live a better life and have a better outcome than if you tried to do it yourself and were miserable in the process. All right, next. Why most initial consultations aren't free. This one's pretty simple, actually. Not simple, but it makes sense. Even for the most basic of meetings, this is why if you've hired me as your attorney at some point, or if you become a client of mine, this is why I have you fill out a client intake form, because I need information. Again, you know more about me than I know about you. The more information you provide me in that client intake form, the better I'm able to help you or know if I can help you. There's a lot of times where I can't help you or I don't handle that type of legal matter. And if you just say just 2 lines of something and I don't know what you're understanding, then we waste mutually both our times, because I can't help you and I have to call you and say, I'm sorry, I can't help you. Or worse, you schedule an appointment with me, I listen to what's going on, and because you weren't detailed in your client intake form, I don't know if I can help you until we get to the phone call, and then I may not be able to, and then we've just spent this time for a maybe, probably not. So the more information you provide, the better. So in a consultation, and even the most brief of consultations, lawyers are looking at all of the facts that you're providing them. We're applying our experience, our education to evaluate your case and your matter, whatever's going on with it. So most attorneys charge for that reason. Not all. There are certain practice areas, for instance, personal injury, where attorneys, generally speaking, do not charge, okay? So don't think that this is a blanket rule that everyone charges, but the reasons for it are that we've spent a significant amount of time and money acquiring this knowledge, skill, and information. And just like you, everyone deserves to be compensated for their knowledge, insight, and wisdom. So do we, okay? So do we, each one of us. And I say that to everyone. Like, I don't expect anyone to ever work for free, no matter what it is. There's this common misconception that attorneys have more money than they actually do, okay? That's not an accurate depiction. Hollywood makes it seem like we can do anything we want, and we'll actually talk about Hollywood on a different video. But Hollywood makes it seem like we have more money than we do, and we can do anything we want, which those are 2 big myths that don't exist, okay? I'm not trying to play woe, poor me, but a legal field has very high overhead. It is not an inexpensive industry to be in. So if you're looking at the charges that we're making, or if we're quoting you our fee, it isn't that we're trying to be greedy necessarily. I'm not saying that's true of everyone, but I'm saying, like, the goal is not to be greedy. The goal is to cover our expenses and have a living, make a living for ourselves, pay off student loan debt. All of these things factor into that. So when you're paying for an attorney, that's part of it. Like, we can't, if we charge nothing, we can't do that. Like, nobody would become an attorney if we did it all for free. If it was free to do, or our expenses were low, that would be different, but they're not. All right. The other thing is, when you're coming to hire an attorney for a consultation, we don't just show up, okay? That's not us. We don't just show up. We do work before it. We do research. We find the information you provide us gives us the tools that we need to give you information in that consultation. So it's not just about the time that we spend in the consultation. It's about the time that we spend before and after the consultation. because we're going to evaluate everything you provide us. We're going to read through it, depending on what it is and the extensive nature of it, and so on and so forth. So it isn't just about the moment, it's about the whole entirety of it, okay? So if you're hiring an attorney, the best thing you can do is be prepared. Fill out their client intake forms. Be detailed with your information. Provide the documents if you have them. You may not, and we understand sometimes that happens, but if you do, don't just not show them to us because it's a little more challenging, okay? And there's a good reason for that. If you don't show it to us, then we're guessing based upon what you tell us, and you may not be right. And so our information is going to be more or less accurate depending on the information that you provide, or our counsel will be more or less accurate based on the information that you provide. So when you're thinking about your relationship and how to build trust, one of the red flags that when I'm looking at a client, and this is not all of them, it depends on the client, but if I don't know you and I send you my welcome email and I send you my client intake form and you don't fill that out and you don't respond to it, and then you get mad because I don't send you a discovery phone call request or I don't schedule a consultation with you for free, it's a building relationship. I don't know you from anyone. So what have I got to work with? Or if I send you the appointment request and then you don't fill out the client intake form till the morning of or the 10 minutes before it, then I'm left guessing as to what it is I'm going to be helping you with or talking about. And there's a lot of time that's spent that we could have already have had that information and saw and looked at this. So when we're not just asking for our health, right? We're not asking because we just want to dig into the personal parts of your life. We're asking to help you. And the more information you provide us, the better we can help you, the more we can give you the best information possible. All right. Next, despite the media, not every case is worth millions. I'm sorry. That's true. Okay? The reason why the media paints this picture of cases is very simple. When the big cases make the headlines, millions gets people's attention way more than averages, which the average just so you know, the average in a court case is only $75,000. That's the average amount recovered. Okay? That's the average. I'm not saying that will be yours. I'm not saying that is your case, but I'm saying when you're looking at there's millions all the way up to millions and then all the way down to nothing, you might not recover anything in your case. It really depends on the case. It really depends on the situation. And so your attorney should manage expectations. And part of that is they're going to say, okay, well, this is based on your damages and the information you're providing us. And so we look at the legal criteria, the facts of the case, and the underlying damages. We don't look at wishful thinking and that it's going to be a windfall for you. In fact, courts hate windfalls. They don't want you to get more money than the damages. The whole point in damages, okay, is to put you in the place, or as close as possible, put you in the place you would have been in had it not been for the bad thing that happened. Okay? Not to get you rich. That's not the goal. Most personal injury cases, the reason why they have such high values to them is because it's very simple. Because if you're permanently maimed and can no longer live as you once did, that has more value than if you have a minor contusion on your leg, right? So just because you might be hurt and just because you might have damages, if they're not severe enough, you're not going to recover the same as someone who has been made a paraplegic or a quadriplegic, or that has long-term life care that's required and they have to have in-house help for the rest of their lives. So when you're looking at this, you need to have realistic expectations. You need to look at your true damages and say, okay, you know, I don't have $1 million case, and most of them aren't even close. I'm not saying that you won't have a higher value than what you think it is, because I'll be fair, most people don't think about there's a lot of peripheral costs that go with bad things that happen and that can be included in your damages. So it might be higher than your original thing, but it's not going to be what the media presents because they're sensationalists, right? Like they're painting a picture of, oh, the McDonald's coffee case, she got millions, right? But that's not what actually really happened. And I would encourage you to actually read that case rather than just relying on media representations because they distorted that case quite severely, the woman who was burnt by the coffee. Next thing is risk versus reward. It's important that you're evaluating it based on, okay, if you might recover a huge amount, okay, versus if you will definitely recover a lesser amount, but still reasonable based on your damages, it might make sense to settle. Because then one, money is more valuable today than it is tomorrow. That's number one. And two, you're not incurring the additional headache, heartache, frustration, and expense of an attorney for the rest of the case. Okay? So when you're thinking on this, think risk reward. Am I going to get the value that I'm going to get? If one side is giving you nothing and you truly have those damages, then yeah, it makes sense to keep going forward. But if they're giving you stuff, if it makes sense, if it's a reasonable settlement based upon your actual damages, mind you, then it's important that you take that under consideration. So when you're talking with an attorney, look at the objective case assessment. A reputable attorney will provide a realistic valuation taking into account legal costs, potential damages, and the likelihood of success. Now, that being said, we do not have crystal balls. We do not read minds. We can give you an estimate, but that's all it will be, is an estimate. We cannot give you an exact amount that you will absolutely positively get. It's literally not possible. Litigation cases are a lot like a game of chess. They make a move, we make a move, they make a move. It increases and decreases, and so different things will improve or not improve your case. So if your expectations are clear sailing through to I've got a slam dunk case, I've got an easy case, there is literally no such thing. Literally. I've got a case right now that I'm trying to recover damages for a client that a judgment already happened for them. They already won. And the defendant is still being difficult with collecting for that judgment. It's not as easy as you might think. So if you have a guaranteed in your pocket $500,000, and I'm just using that as a number, that's not necessarily accurate, and you're like, well, I think we can do better, that's a maybe. Someone once said a bird in the hand is worth two in the bushel. I'm showing my age there, but it's true. Okay? So a guaranteed win, a reasonable guaranteed win, is almost always preferable to a unknowable possibility. Would you rather have $500,000 now, or $300 or $100 or whatever amount of money to take care of yourself and move on with your life, or a maybe $200 or $750 that might happen if you go to trial and it's a possibility, right? There's too many variables. Be cognizant of those things. All right, next. The importance of being honest with your attorney. I know this should be obvious, but it's not. If you are not honest with your attorney, it is very difficult to have a well done outcome. There's several ways that you can not be honest that will negatively impact your case. Number one, if you lie, if you straight out tell them something that's not true. The lie can be done by either a obvious blatant lie, telling something that's not true, or by omitting something intentionally, okay? That is not the same thing as inadvertence. You didn't lie or you didn't omit it because you were trying to conceal it from your attorney. You just forgot about it because you didn't write it down and you didn't do the work on it. You didn't remember to tell your attorney. See the difference between those things? So if you don't tell us the truth, if you don't tell your attorney the truth, it's really hard to get you the best outcome possible. It really is. Because we can plan for what the other side is going to do based upon the information that you provide us. If you lie to us, or you leave facts out, or you inadvertently leave facts out, it makes it really, really difficult to give you a well-done outcome. We might get an okay outcome, but we're going to have a much better outcome if you are honest with us from the beginning. If you lie to us, it's really hard. And I get it. You're afraid that we're going to judge you, but I will be completely transparent. We don't judge you. You obviously are coming to us because of a mistake, a choice, something bad happened in some capacity, some way, somehow. We don't judge you. We want to help you. That's our goal, is to get you the best legal outcome possible. So don't be afraid of being honest and forthright with your attorney. If you remember something after, be upfront with your attorney about it. Tell them, you know what, I totally forgot about this thing. I'm sorry, here it is. Here's the information that I should have told you ahead of time. Have that relationship, right? Okay, next. So one of the ways that you can avoid this is by creating a chronological list or timeline of events related to your case. This will help you with the inadvertence. Do it over a space of time, right? Like when it's apparent that there's going to be a legal thing that's going to happen, start writing. You're going to remember facts in the beginning. Start with the highlights and then start filling in the blanks so that you can have it all ready to go. The more detailed, the better. Because we can always pare things down and summarize and put the facts that we need to in and leave off things. But if you don't tell us that aren't important, don't get me wrong, I'm not saying we would leave stuff off that's important, because not everything is absolutely important. There's material and immaterial facts in a case. Okay. So point is that we can work with more information. What we can't work with is not enough information. So the less you tell us, the harder it is for us to do our jobs, and the harder it is for us to be successful with it. So write things down. Don't leave it to your memory. You will forget details. Keep good notes. Okay? And the importance of this can't be overstated. If your attorney can't trust you because you've lied to them in some capacity, then it causes a breakdown in the attorney-client relationship, and you could end up on the side of having to find a new attorney, right? So be careful, be cautious with what you're sharing. Be willing to be transparent with your attorney when it comes to the legal matter that you're having. All right. Let's kind of talk about confidentiality. Confidentiality is almost, depending on your jurisdiction, everything you say to an attorney remains confidential. We can't even acknowledge that you said it to someone else. We can talk to you about it, unless you give us permission, okay? There are some exceptions to this. Number one, confidentiality and attorney-client privilege do not apply to the crime fraud. So if you enlist our help in a way to try to commit crimes or a fraud of some sort, attorney-client privilege does not protect you, does not protect me. Now, there's a big difference between past crimes, right? So I don't want you to think that if you have committed a crime and you go to an attorney, a criminal defense attorney, that attorney-client privilege doesn't apply, because it does. It absolutely does for past crimes. But if you tell them, now again, this depends on your jurisdiction, so keep that in mind. If you tell them, or you're trying to enlist their help in a way to commit a crime, or you tell them you're about to commit a crime, they may have to report that. It's a big may. Okay, so again, jurisdiction matters. I'm in California, so keep that in mind. So if you tell them that you're going to go hurt somebody, in some states, they have a duty to report you. If in other states, they have they may report you, but they're not required to report you. All right. So the whole point of attorney-client privilege and confidentiality is that it ensures that our communications remain confidential and encouraging an open dialogue. And you may be thinking, sitting back going, yeah, but if I tell them this, that's going to really hurt my case. Well, it might, but you don't know that. You don't know what you don't know. And if you don't provide them with the information they need, they're not going to be able to defend you correctly. The next part of it is foundation of trust. Again, you know us probably better than we know you. So when you're discussing everything and you're being as forthcoming as possible on things, we're not sitting here trying to think of how we can use it against you. We're trying to think of how we can use it for you. The other side's thinking about how they can use stuff against you. That's not what we're doing. Everything you tell us, the more transparent and forthcoming you are, the better the outcome of the case is going to be, because we can work with what you tell us. We can't work with what you don't tell us. So please remember, and confidentiality survives the attorney-client relationship. This isn't, what I mean by that is, even when it ends, we don't get to just go off, start talking to people. There's a few exceptions to this, but for the most part, everything has to remain confidential. So if you're ever in doubt about what can be shared outside of the attorney-client relationship, ask your lawyer or attorney for clarity. Protecting privileged information is essential. We will do everything we can, but if you share it publicly, then it doesn't apply. All right. So as you're thinking on these things, confidentiality is the information you provide us can't be used by us to hurt you or to disclose to anyone, really, unless, like I said, the crime fraud exception, or if there's imminent harm of another person. The other exception, and again, this matters based on jurisdiction, so please keep that in mind, don't think this is a guarantee, is if you claim malpractice against your attorney and or sue, right? If you take them to a governmental agency to try to rectify a bad relationship with your attorney, the courts have found that we have a right to defend ourselves, which means that we can disclose what would have normally have been confidential communications. You cannot like it, you can like it, it is what it is. The idea being that we can't be forced to sit behind attorney-client privilege because of that and not defend ourselves against wrongful things, especially when it's our law license on the line for it. So it isn't a blanket, everything you say, I can never, ever tell it. Those are some of the exceptions. And again, jurisdiction matters because I'm talking about California. Some are like that, some are different. So you have to be cognizant of where you're at, okay? All right. This one is one of the more challenging ones to convey. Not because there's part of your brain that says one thing, and then there's the other part of your brain that says, no, 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 I want this. So there's part of you that says, yeah, that's realistic, that's possible, I get it. And then there's the other part of me that says, but what if the grand, amazing thing happens? That's the unfortunate truth. And the media doesn't help. So you need to look at your case, and your attorney should talk with you about this. Is your realistic versus idealistic outcomes? If you are, there are no guarantees in litigation. There's no guarantees in life. But the problem is people will come to us with these perfect ideas of what they want of an outcome. And then, so they give us the version of the facts that most supports that. And then as things happen, we'll get additional facts, we'll get different information, and they're still holding on to this perfect, even if the facts no longer support that. So that's a problem, because like I was saying earlier, a case is a lot like a chess game. You don't know what the other side's going to do. You don't know everything that's going to happen. You have to move based on what happens. So part of it is your attorney should discuss these things with you. Every route that you take has advantages and challenges. So talk to your attorney about what those opportunities and challenges are so that you can be well-informed and understand what's happening with your case. Okay? Next part of it is regular updates. By the way, there is no perfect case. There is no perfect outcome. There is no easy case. If there's a case, there's going to be a difficulty in it. Okay, that's just the truth. There is no, in litigation, there's no straight line to a successful case. It's very up, down, around, lots of variations. So don't feel like it's going to be an easy thing once it starts. That's why you want to hire an attorney. It's going to be difficult. You might want to have that person that's going to be better at it than you, especially if the other side's represented by counsel. So staying informed, regular updates, communicating with your attorney on the regular. If you haven't heard, if there's a hearing coming up and you haven't heard for a while, check in with your attorney. They're busy. It's not that they don't want to communicate with you. It's that they might not have the time to communicate with you at that moment. And you popping up to say, hi, I'm here, what's going on, is perfectly acceptable. And we've talked about over-communicating. Avoid that. But communicating and staying informed is very crucial to your case's success. You will be much happier if you do that. All right. So you're going to want to have a candid conversation with your attorney about best case, worst case, and most likely scenarios, and anything along those lines, okay? Because you need to know that there's lots of possibilities that could happen. The more prepared you are for those possibilities, the more successful you will be and the better you will get through it mentally. If your goal, if you stay stuck on your idealistic perfect outcome, you're more likely than not going to be disappointed. In law, in the court system, there is no such thing as a perfect outcome. There is no such thing as an ideal outcome, not really. And sometimes, I'm not saying this is all the time, but sometimes you will be pleasantly surprised and things will work out better than what you were hoping they would. But generally speaking, they're not going to work out perfect. So don't put your expectations on perfection in a court case. Okay? So these are all things that you can do to help build that trust with your attorney. Being informed, using the attorney-client privilege correctly, having realistic expectations about the case. All of these things will help you to have the best legal outcome possible and to have a good relationship with your attorney. The better the relationship with your attorney, the more they're going to fight for you. True story. The better you treat our staff, the better you treat us. And I'm not saying that you have to, I'm not suggesting in any way, shape, or form that you have to treat us any better than, I'm not any better than what we deserve. I'm saying don't abuse us either. Don't yell at us when things don't go your way. Don't treat us with disrespect just because we can't obtain that a perfect outcome. We want to get you the best outcome possible. That's why we're here. We're not here to hurt you. We're here to help you. And things won't always go our way. Sometimes we win, sometimes we lose. We can argue something and the judge just doesn't agree with us, or the jury, or fill in the blank, somebody else. We cannot control everything that happens. And as I tell my kids all the time, the only people you can control is yourself. That's it. Those are the people you can control. You cannot control anybody else. So if you want to have that successful relationship, make sure that you're controlling yourself when it comes to these things. Make sure that you're taking responsibility for the things that you can control. By being proactive, doing all of these things that we've talked about over the last couple of days. This will help your attorney-client relationship, and you will have a much better outcome. Even if it's not a perfect outcome, but because you'll have had a better journey, because you'll have had a better relationship with your attorney, you will have a more successful outcome, regardless of what the final verdict is, whatever the damages are. It's okay to be disappointed when things don't go your way. I promise you we're disappointed too. That's perfectly acceptable. But don't yell at your attorney. Don't yell at their staff. Don't yell at the court. For whatever reason, it wasn't found in your favor. You can disagree with it. There's plenty of laws that I disagree with, but I still have to follow them. I still have to go by them. I have to follow what the judge orders. He's a human being. He's a judge. He's been doing it for a while. That's the whole point of going to litigation. All right. So that's it. So if you've gotten value out of this video, don't forget to hit subscribe and like. And hey, I've got stuff back. There's a button.